Hi, I'm Ed Jager, chair of the subrogation group at White & Williams. Welcome to Subro Sessions. If you have any questions or suggestions for future topics, email us at www.info@whiteandwilliams.com.
Hello, everyone. Thank you for joining us for another amazing episode of Subro Sessions. I am Gus Sara, and I'm here today with my esteemed colleague, Mike Abed.
Hi, Gus, though I think you might have sold me or oversold me on the esteemed part.
That's what I do. Today's topic is failing safely, discussion on product design defect cases related to failsafe components. We are going to briefly discuss the general elements of proving a product design defect claim. And then after that, we will provide some examples from our own experiences dealing with design defect cases relating specifically to failsafe components.
Since we're lawyers, it's only right that we're going to start off with a bunch of disclaimers and caveats.
You would.
Play to my strengths. We are going to discuss the common elements of establishing a product design defect claim as set forth in the Restatement of Torts. And then we'll provide specific standards adopted in Pennsylvania. But it is more important to note that the standards in each state can and do vary. Later on, we'll talk about some contrasts with other states. Some states are more stringent, and others have modified the restatement standards. The essential provision in the Restatement of Torts regarding products liability is a product is defective when, at the time of sale or distribution, it contains a manufacturing defect, is defective in its design, or is defective because of inadequate instructions or warnings.
According to the Restatement of Torts, and that's the third edition, a product contains a design defect when the foreseeable risks of harm posed by the product could have been reduced or avoided by the adoption of a reasonable alternative design by the seller or other distributor or the manufacturer. And the omission of the reasonable alternative design renders the product not reasonably safe for the consumer public. So, as you can see in the third Restatement of Torts, the standard included more of an emphasis on showing a reasonable alternative design. And that's different from the other restatements of torts. Over the years, they have incorporated the reasonable alternative design element into the factor test as a more prominent element over time. This was not always the case, but I guess as the courts have decided products liability cases over the years, it was determined that it was an important modification to be made, and that was made in the third Restatement of Torts. So nowadays, to establish design defect, a claimant needs to have adequate support to establish that the product could have been designed in a manner to further minimize or prevent the danger. This is why the appropriate industry expert has become increasingly important in design defect cases, which we'll discuss a little later. As a Pennsylvania barred attorney, I figured I would briefly discuss the standards that apply in Pennsylvania. There are actually two standards for product design defect cases that courts have used to analyze product cases. The first is the consumer expectation standard. Under this standard, a defective condition is a condition upon normal use that makes the product dangerous beyond the reasonable consumer's expectations. This standard is based on the expectations of reasonable consumers of the dangerous nature of a product. The factors in determining a reasonable consumer's expectation are the product's target user, nature of the product's intended use, and any express or implied representations or warnings by the manufacturer or seller. The other standard is the risk utility standard. And this standard is essentially based on a risk reward or cost benefit analysis and examines whether the seriousness and likelihood of the resulting injury from the product's use was outweighed by the cost or burden of preventing the harm related to or the occurrence of the injury. A common example to kind of explain the risk utility standard is a knife, right? Meant to be sharp, have to be sharp. In fact, the sharper they are, the greater the utility. And it's very difficult to design away that danger. So if one were to cut themselves with a knife, it would be very difficult for them to prove that that was the result of a product defect, especially according to the risk utility standard.
Now, as a California barred attorney, I'm going to be looking at the California standards for product defect, which sound very similar to the standards that Gus just shared with us. But I think we're going to see that in practice, they're a little bit different. Under California law, there are also two accepted ways of proving a product defect. One is called the consumer expectations test, which is very similar to Pennsylvania's consumer expectations standard. And the second is called the risk-benefit test. Now, to be clear, these tests are not mutually exclusive. They're just alternative theories. Sometimes they're both going to apply in any given case. Now, because of the way California law is practiced, I'm actually going to start with the jury instructions, which is one of the, I think, crucial documents that sometimes gets overlooked when making an argument to a court. The California instructions tell us is that for the consumer expectations test, a design is defective if a product fails to perform as safely as an ordinary consumer would expect it to perform when that consumer uses the product in an intended or reasonably foreseeable manner. So there's four elements of this test as far as the California courts are concerned. One is fairly obvious, that the defendant themselves actually manufactured, distributed, or sold the product. They don't have to do all three. Any one will get you where you need to go. The second is the product did not perform as the ordinary consumer would have expected it to perform when they either used it as intended or potentially misused it in a foreseeable manner. Obviously, 3 and 4 are the plaintiff was harmed and that the product's failure to perform safely was a substantial factor in causing that harm. The second test, the risk-benefit test, is, again, very similar to Pennsylvania's test. Here, a plaintiff need only show that the defendant designed a product and that that product caused the plaintiff's injury. That actually shifts the burden in California to the defendant to prove that on balance, the benefits of the challenged design outweigh the risks of danger inherent in such a design. And to go back to Gus's, I think, excellent example, there are some cases where you simply cannot remove the danger. The sharper the knife, the better it'll perform. Ergo, you can't make a dull knife to prevent people from cutting themselves and still expect the knife to do what the consumer purchased it to do. Now, California courts will look at a number of different factors when evaluating whether the benefits of design outweigh its dangers. But one of the starting places, and I think the starting place for any good plaintiff's attorney here, is the gravity of the potential harm resulting from the use of the product. Even if it's not necessarily probable that someone's going to get hurt, but if the way the product hurts them is so badly that they are mortally injured or are very close to it, I think courts will be stricter in that kind of a design than they might be if the injury possibility or the severity of the injury wasn't quite so great.
And obviously, over the years, as technology has advanced, as engineering has advanced, product manufacturers and designers have took it upon themselves, probably inspired by a slew of lawsuits coming their way, to try to make their products safer by installing fail-safe components, to anticipate the likelihood of certain types of failures and to put in place a safety mode to try to reduce that failure. And there's times where that particular component would either fail to work, which leads to its own theory of liability on design defect, or the safety component itself tends to fail, which is ironic because the intention of these components are to avoid a failure. And instead, they're adding another potential cause of the failure. And we're going to go over some examples. The first being a case I had involving a failure of an oil-based wall heater, which caused a fire. As this particular case did not result in any personal injuries, but I did handle the property subrogation side of the case. The homeowners had central heat, but decided to add a bathroom on the first level. They hired some contractors to do that. And they decided to do that instead of running ductwork, which would require them to knock down drywall on the original part of the home. So they figured they would just put a wall heater behind the door of the new bathroom. After about a year of operation without issue, the heater catastrophically failed while everyone was sleeping. Thankfully, everyone got out safely, but it was a very traumatic experience for the family. I actually remember the father breaking down and crying during the deposition. It was actually quite dramatic. We conducted our site inspection immediately after the loss, as we try to do, and we found that the fire originated at the heater. We then pulled out the evidence and coordinated a joint evidence exam, as typically occurs. It was discovered that the heating element was poorly designed. In addition, the capillary tube, which was essentially used as a temperature meter control, was not in the proper position to shut down the heater when it overheated. We were able to prove that by getting exemplars of ones that were properly used and had the right size and length of the capillary tube. We were even able to get exemplars of the same model as part of a manufacturing defect claim that we asserted alongside a design defect claim. We were able to establish and settle with the manufacturer that this particular product was not only probably not manufactured right in accordance with their own design, but that their actual design was improper because there were alternative designs out there in the market with this capillary tube failsafe component, more robust, longer, and a more effective safety component than the one that existed in this heater. A second example is a dehumidifier case that I handled. About a decade ago, a particular manufacturer, Gree, a large appliance manufacturer, issued a recall for their dehumidifiers because they were overheating. There's been several manufacturing lines that have had numerous failures resulting in overheating, but the Gree one had led to dozens of fires. In fact, I believe hundreds of fires and dozens of cases filed against them. They initially issued a recall about overheating and the unit causing smoke damage and fires. They updated the recall in October 2013 and expanded it 2014. And one of their expanded notations was that the thermal cutoff had a risk of overheating. Now, the thermal cutoff is essentially a component that is like a temperature meter as well. And when the compressor overheats, it's designed to shut down. Most of the time with the failsafe defect, the theory is that the failsafe did not do its job in preventing the failure. But with some of these dehumidifiers, like this particular Gree defect, the actual thermal cutoff fuse was the thing to overheat and catastrophically fail. So this failsafe literally came back to bite Gree because it wasn't properly installed and the fuse itself wasn't protected from the heat that would occur when this dehumidifier was operating for a certain period of time. So you know you're in a bad situation when your failsafe catastrophically fails on you. So when I handled one of these, it actually originated in the basement of a convent for nuns. It goes without saying that the manufacturer was very interested in settling this one pre-suit. Can't find a much better plaintiff than a nun convent. The site inspection revealed that there was nothing else in the area of origin, so no one disputed that the fire came from this Gree unit. So that part was pretty straightforward. And I will never forget the evidence examination for this one because I never saw a compressor so cooked before in my life. And I've seen a few compressors cut out, the metal casing cut and the interior examined. But with this particular one, the windings inside the copper were so cooked and there was several points of arcing everywhere, which tells us that this unit was energized for a while during the fire, meaning all the safety features of the product were ineffective. So rest assured, we settled that one pretty quickly. So to wrap all this up, the main considerations for handling a design defect claim are as follows. One, you have to consider the use of the product. That always comes into play, especially when you find that the product was not being used correctly. That's always one of the top defenses asserted by the product manufacturer. And that's no different for failsafe product cases.
Now, one of the things you may have noticed that Gus and I haven't mentioned yet is the industry standard. Now, obviously, that's going to be a fact question depending on what product you're analyzing, but we wanted to point out the importance of having an appropriate industry expert and how that can potentially pay off later on in your case. in one particular California case, the California Supreme Court actually opened the door of evidence a little bit and allowed a product manufacturer, as part of its defense, to present evidence of what the industry custom was. Now, if you'll remember back to our explanation as far as the standards, industry custom is not technically one of the standards the court's supposed to consider. However, in this context, the Supreme Court held that the evidence was relevant and admissible because it was introduced to address the feasibility and cost of alternative product designs. Now, that kind of insight will do one of two things. It may help convince a jury that either the defendant was especially negligent or that the defendant acted particularly reasonably given the standard of the industry it operates in. But in order to get that level of insight, in order to understand the claim from that holistic perspective, you've got to have the correct expert. Now, Gus, I know you have a lot of experience with this. Could you elaborate?
The industry is full of forensic experts, and I'm hiring experts every day. But when it comes to a design defect, you need more than just a forensic engineer. You need an engineer who has experience in the design and manufacturing of that particular product. I've had automobile cases where I was alleging defective design, and I had to find an expert who had a background working for a car manufacturer and working on specific designs, or they're going to have to face a motion to exclude. And there's a good chance that a court would be unwilling to allow an expert to testify as to alternative designs and the appropriate industry standard for designing products if they have no experience in actually working in that industry. There's an example, a recent court decision where a very experienced forensic expert tried to offer a testimony that a stove was not properly designed because there wasn't a switch that had to be pressed before the knob can be turned to activate the burner. There's been a series of fires related to pets, particularly big dogs, pushing in and turning the nozzle, activating the gas burner and causing a fire. So there's been I don't know if it's a class action, but there's been a few law firms that have bundled up a series of product or of stove fires and have asserted this theory of liability that these stoves are designed defectively because there's an alternative design that could make it safer, such as adding a button that you have to push in addition to turning the nozzle. Unfortunately, the court excluded the expert from testifying, although this particular expert, had investigated over 500 fires due to mechanical failures of stoves and stove-like products. They found that there was not enough background in his resume to qualify him as an expert regarding the design and alternative designs of stoves in that industry. So essentially, the plaintiffs in that case would have benefited from finding an expert who actually has a background in designing stoves to testify as to the appropriate alternative design. Another factor to consider is not to rule out a manufacturing defect. A lot of times, and I'm sure Mike can attest to this, you can argue both at the same time as kind of like a fallback, saying, hey, even this one wasn't manufactured to your design standards, and plus there's a design defect. Kind of hit them with the 1-2. And when feasible, you should really consider using exemplar units so that your expert can better understand the product. And it's good to buy, other examples of the alternative design that you're trying to prove. Maybe conduct testing, which I've done. In fact, that oil-based heater case that I discussed earlier, we did buy a few other models and we conducted testing to see that the capillary tube for that heating element was turning the heater off at a certain temperature, unlike the one that we alleged caused the fire. So we just threw a lot at you, and we could talk forever about this particular topic, which I particularly find interesting. You can reach out to me or Mike anytime should you have any questions.
Absolutely. If you're still with us and we haven't put you to sleep yet, thank you so much for your attention. And just know, shortly following this podcast, we'll be doing a follow-up podcast on workers' compensation subrogation recovery and how product defect theories allow us to recover on behalf of our clients in that world as well.
Thank you for joining us. See you next time on Subro Sessions.
Thank you for listening to Subrose Sessions. Stay tuned for more episodes from the subrogation group at White & Williams, and visit whiteandwilliams.com to learn more about the firm, our group, and this podcast.